Hi, I'm immigration attorney Heather Poole. Today I'm speaking to you about common options that may be available to you if you are in a deportation proceeding. This is also called a removal proceeding. Always consult a competent, licensed immigration attorney before filing for any relief in court, so you know if you qualify for it. You are responsible for proving that you qualify for the relief. This is very important. Generally, it is not a good idea to apply for relief that you know you don't qualify for, even if the judge or ICE trial counsel does not realize at the beginning of your case. Further, if you know there's no way to prove your case, you shouldn't file for relief just to buy yourself time. Also, do not lie to the immigration judge or apply for relief based on lies. This will come back to haunt you later. The court sees many fake asylum claims, which can bar you for life from any future immigration benefit. Applying for relief you don't qualify for or lying to an immigration judge always looks worse to an officer reviewing your file at a later point in time. Let's say you are applying for a waiver, which is a discretionary action, at a consulate abroad. They will see that you have filed for relief before that you did not qualify for, and you were using it just to buy time, and could deny your current case based on discretion, because they will conclude that you were just using the system. However, there are many options in immigration court. The following is the most common types of relief available to an immigrant faced in a removal proceeding. If granted, the relief could lead to a green card, cancel your removal, and allow you to stay in the United States, depending on your circumstances and what you apply for. The first type of relief is called voluntary departure. This is the most common form of relief from removal. You have to voluntarily agree to leave the United States within 60 days at the end of the proceeding. The judge may grant you a period of up to 120 days to leave the United States, but it's very careful to not overstay this period of time. Now, why would you choose a voluntary departure as opposed to staying in the United States? Well, voluntary departure is not a removal order. It allows you to apply for other relief from outside of the United States without having a removal order on your record. For voluntary departure, you must leave at no expense to the U.S. government. You have to pay for your own plane ticket back home. And you must depart on time. If you don't depart on time, there is a 10-year bar to any future adjustment of status, which is applying for a green card in the United States, or cancellation of removal, and other forms of important immigration benefits that you may be eligible for if you leave the U.S. on time. Your voluntary departure grant automatically turns into a removal order on top of this if you don't leave on time. A removal order has a 10-year bar to re-entry. This is time that you are barred from coming back into the United States. Keep in mind that certain people do not qualify for voluntary departure as a form of relief, so it's always important to talk to an immigration attorney about your particular facts. Another form of common relief is called cancellation of removal. There are two types of cancellation of removal. The first is for people who are already lawful permanent residents but have been placed in removal proceedings because of criminal acts, because of abandonment issues, and other issues that even permanent residents can get deported for. If granted, cancellation of removal allows you to become a permanent resident, to keep your green card. To qualify for cancellation of removal, you must have been a permanent resident in the United States for the last 5 years. You must have continuously resided in the United States for at least 7 years prior to deportation proceedings being instituted against you. The 7 years has to be from the time of your last lawful admission. You also cannot be convicted of an aggravated felony. An aggravated felony has a broader meaning than what you would consider a felony to mean under a state code. Just because something is a misdemeanor under state law, it may be considered an aggravated felony under federal immigration law. This can be very dangerous for purposes of removal. Cancellation of removal is also available for people who are not permanent residents. Cancellation of removal for non-permanent residents, which can be anyone who is here undocumented, who overstayed their visa, or is in removal proceedings for another reason. To qualify for cancellation of removal as a non-permanent resident, you must have been continuously present for at least 10 years. You must have been a person of good moral character during that time, so they're definitely going to look at your criminal record. And you cannot be convicted of any criminal offense that would trigger a deportation ground. Whether an offense under state law is one that triggers deportation is something you should discuss with your immigration attorney as soon as possible. The best case scenario is always to talk to your immigration attorney before making a plea to any sort of criminal case. For both types of cancellation of removal, you would have to prove that your U.S. citizen or permanent resident spouse, parent, or child would suffer extremely unusual and exceptional hardship if your case was not granted and you had to leave the United States. This is an extremely difficult standard to meet, but the case is not impossible. Another common form of immigration relief in a removal proceeding is political asylum. To be granted political asylum, you must show fear of returning to your home country because you have been persecuted in the past or fear that you will be persecuted in the future if you return to your home country. Your fear of being persecuted in your home country must be based on persecution due to race, religion, national origin, membership in a particular social group, which can include gender, or your political opinion. Political asylum claims can be difficult in immigration proceedings because usually political asylum claims must be filed within 1 year of entry into the United States. However, there are circumstances where you can submit an application after the 1 year deadline. Similar forms of relief to asylum are withholding of removal and the UN Convention Against Torture applications, which are also available in removal proceedings. If you are granted political asylum, travel back to your home country after you are granted permanent residency may be extremely difficult due to the possibility of undermining your credibility for a previous asylum claim. Think about this before applying for asylum, unless you can show that the fear is no longer necessary. Another common form of relief in removal proceedings is called adjustment of status. Adjustment of status is the process where an immigrant can obtain a green card while in the United States, based on an immigrant visa through a family member or employer without having to travel to a consulate abroad to process their green card. To qualify for adjustment of status, you have to prove to the judge that you legally entered the United States or qualify under 245I or any other exception to the usual rule that you entered the United States legally. You also have to prove that no other exceptions apply that would deny you a green card, such as health or criminal issues. You also have to prove to the judge that you have an immigrant visa that is immediately available to you now to apply for. And certain people are barred from applying for adjustment of status. There are other types of relief available to you in immigration court, depending on your circumstances. These above that we've been talking about are the most common. If you need my help, feel free to call me or complete our consultation questionnaire on our website, humanrightsattorney.com. Thank you and good luck.